Well, I think we're a long way. We haven't seen the complaint yet. I'm sure Google will move to dismiss it. It's, unlike Microsoft here, the problem from the very beginning has been the lack of consumer harm. So Google's products are well liked by consumers. They're free, unlike the Microsoft case where the whole objective of Microsoft was to enable itself to continue charging high monopoly prices for Windows. So they're very different cases. The conduct that apparently is going to be alleged is also very, very different, much more severe in the Microsoft case.
I followed a little bit the European antitrust charges against Google from Margaret Vestager, who's their top antitrust commissioner. It looked a lot like these kind of similar allegations. They also went after Google for allegedly preloading the app, for instance, on certain phones and that sort of market dominance. That ultimately led to a fine. What do you think the Department of Justice is after here?
From what I understand, the allegations may be similar, but American law is very different. If I can illustrate how different it is from Microsoft to Google, I'll use the example of Apple. So in the Microsoft case, Apple wanted to load not Microsoft's Internet Explorer, but Netscape Navigator on their systems. They thought it was better for consumers, and Microsoft coerced them. They threatened the consequences to Apple if they didn't do that. The court said it was an inter arum threat. Here, it's entirely different. Apple, from what I know, decided on its own to load search and Chrome into its system because Google search is the preferred search by consumers, and other companies had a chance to compete for it. So it wasn't something that Google got because it coerced Apple, but something because Apple wanted itself. It's very, very different.
Well, Stephen, what should we be looking for? What will you be looking for in the complaint, perhaps, to give you a sense as to the government's argument here and the weight of that argument?
Well, so I think, from what I know, the arguments were fairly weak. I'll be interested to see, what they say. I think it's also very striking, as you've already noted, that there are no Democrats on Microsoft. It was a bipartisan effort from the beginning. DOJ here evidently made an effort to persuade the Democratic and all Republican AGs. In fact, they don't even have all Republican AGs to sign on. And there was a rebellion in the ranks, according to the Wall Street Journal and the New York Times, that the staff attorneys didn't want to sign on. So it's a very bad look coming out of the gate. Judges are human beings. They read this. I think it's going to be very tough sledding for DOJ here.
Yeah, there's this sense that the Attorney General rushed it perhaps to get it out before the election.
Correct.
But give our viewers a sense, though, in terms of the time that we're talking about over which this conceivably will stretch out.
It'll probably stretch out years, which is what the Microsoft case did between everything that has to happen. So Google has the right to discovery. The government has been doing some investigation, but Google hasn't had a chance to do that. So there will be a significant amount of time, a year perhaps, I don't know. It's up to the judge to set a time for discovery. Then there will be a trial on Microsoft. The trial spans 6 months. And then, the judge had to write a decision, and there was an appeal. So we're talking about a very lengthy process.
Shepard Smith here. Thanks for watching CNBC on YouTube.